welcome to our program. I'm Rachel Pierce, and I'm joined today by Krista Rubin. In collaboration with the FJC, we are happy to be here to bring to you Sentencing and Guidelines, New Amendments for 2011. As the title of our broadcast indicates, today's broadcast is going to focus on the most recent amendments to the United States Sentencing Guidelines. Those amendments did in fact go into effect November 1st of 2011. And for those of you who have been anxiously awaiting the color of this year's guidelines manual, you can see it's a lovely periwinkle color. So again, we'll be focusing on the new amendments that did go into effect November 1st of 2011. Our goal today is to provide you with an overview of these new amendments and a greater understanding of the application of these guideline changes. However, before we get started, we must briefly go over some housekeeping items for today's program. First housekeeping item is going to be CLE credit. For those of you who are interested in obtaining CLE credit for this broadcast, you can look to the FJC's DCN site for additional information. You'll see that link to the DCN site at the bottom of your screen now, and you'll also see it periodically throughout the program. Our second housekeeping item, materials for today's broadcast. Also on the FJC's DCN site, you'll find links to the supporting materials for our broadcast today. First, the reader-friendly version of the new amendments that went into effect November 1st, which highlights the specific changes, the actual language that is, that has been made to the guidelines, and also provides a synopsis for each of the new amendments. A link to the official version of the new amendments is also provided. That is a link to the November 1st, 2011 Guidelines Manual. The new manual and the reader-friendly version of the new amendments can also be accessed on the Commission's website at www.ussc.gov. You see that address at the bottom of your screen, and again, that will also be referenced throughout our broadcast today. Third housekeeping item is questions from our viewers. As detailed in the announcements for this program, we have been and are still accepting questions on these new amendments that went into effect November 1st. One way you can get your questions to us during the broadcast is to fax them directly into the studio. You can see that fax number now at the bottom of the screen, and again, you'll see that periodically throughout the broadcast as well. In addition to faxing in your questions, you can also email your questions to us directly into the FJTN studio. So whether you're at your PC or you have your BlackBerry or maybe you have a laptop with you, if you've got a question, you can go ahead and email that into us. The address for that is fjtn.gov, and again, you'll see that periodically throughout the program. We do encourage you to send us your questions. As I said, we have gotten some ahead of time, and we're going to address those on air today. And any additional questions you may have as we go along, we'll do our best to address those today. Final housekeeping item, the topics for today's broadcast. We'll start our program today by discussing the amendments implementing the Fair Sentencing Act of 2010 and its retroactive application. We have received several questions in advance of today's broadcast regarding this particular amendment, and we'll address those questions immediately following our discussion of that amendment. Next, we will turn our attention to various other amendments that went into effect November 1st, 2011, including guideline amendments addressing supervised release, firearms offenses, illegal reentry offenses, fraud offenses, and mitigating role. We will then address questions regarding these particular amendments.
And as usual, we have a lot of information to share with you during today's broadcast. So we're going to jump right into our discussion of the amendments implementing the Fair Sentencing Act of 2010. Now, as most of you are aware, the Fair Sentencing Act of 2010 was enacted on August 3rd of 2010. This bipartisan legislation addressed the disparities in federal cocaine sentencing policy. This act resulted in changes to statutory penalties for crack cocaine offenses and also provided a number of directives to the U.S. Sentencing Commission regarding specific factors to be addressed in the guidelines for offenses involving not only crack cocaine, but all other drug types as well. Now, the Commission first addressed this legislation in emergency amendments to the federal sentencing guidelines that went into effect last November 1st of 2010. However, as required by the Commission's organic statute, any temporary emergency amendments must be repromulgated during the next amendment cycle as regular permanent amendments to the guidelines. The Commission has repromulgated the amendment as a permanent amendment, and the amendment is essentially identical to the emergency amendment from last year, except for additional guidance regarding maintaining a premises under 2D 1.1 B12. So as a result, the amendments implementing the Fair Sentencing Act will be very familiar to the majority of you watching this broadcast because you've been using these amendments since November of last year. Now, the amendment implementing the Fair Sentencing Act of 2010 is listed as Amendment 750 and is divided into three parts, Parts A, B, and C. Now, Part A of this amendment addresses the statutory changes associated with the penalties for drug trafficking offenses involving quantities of crack cocaine. This part of the amendment changes the drug quantity table for crack cocaine to reflect the new quantities of crack required by statute to trigger the appropriate mandatory minimum penalties. The Fair Sentencing Act amended the drug trafficking statutes to require 28 grams of crack cocaine to trigger the 5-year mandatory minimum penalty and 280 grams of crack cocaine to trigger the 10-year mandatory minimum penalty. So Part A of Amendment 750 amends the drug quantity table at 2D 1.1c to reflect these statutory changes. As you can see in the following graphic, the drug quantity table has been amended to reflect these new drug quantities that were established by the Act that trigger the mandatory minimum penalties for crack offenses. 280 grams of crack, which triggers the 10-year mandatory minimum penalty, is set at offense level 32, which is roughly about 10 years of imprisonment. 28 grams of crack, which triggers the 5-year mandatory minimum penalty, is set at a base offense level of 26, which is roughly 5 years of imprisonment as you look on the sentencing table. Let's move on now to Part B of the amendment. Part B of Amendment 750 adds various aggravating and mitigating factors to the drug trafficking guideline 2D 1.1. These aggravating and mitigating factors respond to the directives to the U.S. Sentencing Commission that were contained in the Fair Sentencing Act. These aggravating and mitigating factors apply to all types of drugs. They do not only apply to offenses involving crack cocaine. So anyone who is being sentenced under Guideline 2D 1.1 could be eligible for one of these new aggravating or mitigating factors as long as their relevant conduct would uphold the application of these particular new specific offense characteristics. Let's take a look at the aggravating factors that were added to the drug guideline. The aggravating factors added to 2D 1.1 are new specific offense characteristics. The first specific offense characteristic, B2, addresses violence. That is the use, the credible threat of, or the direction to use violence. Specific offense characteristic B11 addresses bribery of a law enforcement officer to facilitate the offense. Another new specific offense characteristic is found at B12 of the guideline, and this provides an increase for maintaining a premises for the manufacture or distribution of a controlled substance. Specific offense characteristic B14 applies to defendants who qualify for an aggravating role enhancement under Chapter 3, that is 3B 1.1, and whose conduct in the drug offense involved an additional factor, such as witness intimidation, importation of a controlled substance, influencing an individual to participate in the offense, or involving particularly susceptible individuals, such as minors or pregnant women. Part B of Amendment 750 also provides a couple of mitigating adjustments to Guideline 2D1.1. First, the base offense level for a defendant who receives an adjustment for minimal participant at Guideline 3B1.2, that is a 4-level decrease under that guideline, may not have a base offense level of greater than 32. Second, specific offense characteristic B15 provides an additional reduction for a defendant who is a minimal participant, again, who receives a 4-level decrease under Guideline 3B1.2, and who also has 3 factors as described in this new specific offense characteristic, including no monetary compensation and minimal knowledge of the scope of the offense. For a more detailed look at the specific changes contained in Part B of this amendment, we invite you to look at the amendments broadcast from last year, Sentencing and Guidelines, New Amendments for 2010, which can be found both on the Commission's website at www.ussc.gov as well as on the FJC's DCN site. The last part of Amendment 750, Part C, also addresses a statutory change resulting from the Fair Sentencing Act. Part C of the amendment addresses the elimination of the mandatory minimum penalty for offenses involving simple possession of crack cocaine. To address the elimination of this mandatory minimum of 5 years for simple possession of crack cocaine, Part C of the amendment eliminates the cross-reference at the simple possession guideline, 2D2.1, to the drug trafficking guideline, 2D1.1, for crack offenses. Rachel, now why don't you tell us what is the significance of this particular amendment having 3 distinct parts?
Well, Krista, the significance of this amendment being broken into 3 parts, that is A, B, and C, is that the Commission specifically designated only 2 parts of this amendment 750 that would be retroactive, or defendants could apply for a reduction in their sentence only under these 2 parts. That is, first, the change to the drug quantity table, which is Part A of the amendment, and the elimination of the cross-reference, which is Part C of the amendment. Those 2 parts have been added to the list at 1B1.10C, which is the list that designates an amendment as eligible for retroactive application. 1B1.10 is the guideline that provides guidance to the courts in considering reductions pursuant to the statute at 18 U.S.C. 3582C. Section 3582 of Title 18 permits the court to reduce the term of imprisonment a defendant is serving as a result of a change in the guideline or an amended guideline range. Now, generally, the defendant is eligible if he meets 3 criteria. Number 1, the defendant has to be serving a term of imprisonment. Number 2, the amendment needs to be listed as eligible under 1B1.10C. And number 3, the guideline range applicable to the defendant needs to subsequently be lowered as a result of the listed amendment. Now, in order for the court to establish whether the amended guideline range has resulted in a lower guideline range for a particular defendant, the rules established at 1B1.10 allow the court only to substitute the amendment listed at 1B1.10C into the guidelines as applied at the previous sentencing. All other guideline application decisions from the previous sentencing remain unaffected. What that means in the context of the retroactive crack amendment is that the court is permitted only to substitute the change to the quantity table that the defendant was previously convicted of a drug trafficking offense involving crack cocaine. And I want to point out here, we're talking about crack cocaine offenses, not powder cocaine offenses. The court is only permitted to revisit that quantity table and no other decisions that were made at the previous sentencing. An amendment listed at 1B1.10C may not always result in a lower guideline range. Sometimes the operation of another guideline, such as the career offender guideline, as an override, may prevent a listed amendment from lowering the defendant's guideline range. Sometimes a statutory provision, such as the mandatory minimum or a mandatory minimum that is in excess of the otherwise applicable guideline range may prevent the lowering of a guideline range for a particular defendant. Other specific examples of situations in which the crack amendment would not lower the otherwise applicable guideline range include cases where the quantity of crack cocaine is 8.4 kilograms or more, certain cases involving multiple drug types, cases in which the quantity results in the same base offense level, and we know sometimes that happens, or where the original base offense level was a base offense level of 12. Now, there are 3 limitations on the amount of reduction available for a particular defendant once it has been determined by the court that that defendant's guideline range has in fact been lowered. First, the court cannot reduce the term of imprisonment to less than the term of imprisonment that the defendant has already served. Second, if the previous sentence was within the previous guideline range, the term of imprisonment cannot be reduced to less than the minimum of the amended guideline range. Third, if the previous sentence was a departure or a variance from the previous guideline range, the term of imprisonment cannot be reduced to less than the minimum of the amended guideline range. However, there is an exception for substantial assistance. Now, this limitation is a new addition to the guideline at 1B1.10, effective November 1st, 2011. The only comparable reduction for a sentence below the guideline range in a case involving a reduction for substantial assistance. That's the only case where we can have this exception. A departure for any other reason or a variance that was imposed at the time of the previous sentence is not a situation in where the court can give a comparable reduction. And in those situations, the court is limited to no less than the minimum of the new amended guideline range.
Now, as you mentioned in our opening, in advance of the broadcast, we received several questions about these amendments and retroactive application. So before we leave the topic of the Fair Sentencing Act amendments, let's turn and look at those particular questions while the topic is fresh on our mind. So let me ask you the first one.
Okay.
We have a defendant who is eligible for a reduction in sentence pursuant to Amendment 750, Part A, the Trafficking in Crack Cocaine Amendment. At the time of the original sentencing, the defendant received a downward departure for adequacy of criminal history pursuant to Guideline 4A1.3. After calculation of the amended guideline range, will the defendant still be eligible to receive a comparable reduction pursuant to that guideline, 4A1.3, adequacy of criminal history?
And see, this is a great question because it really illustrates that exception that I was just talking about. Now, under the previous guideline at 1B1.10 that was in effect under the previous retroactive application for crack defendants in 2007, this defendant would have been eligible for a comparable reduction. The way the guideline is written now, effective November 1st, 2011, the only cases where the court can give a comparable reduction are those in which initially the court gave a substantial assistance reduction. So in this particular case where the defendant got a departure based on adequacy of criminal history, the court would be limited to the minimum of the new amended guideline range and would not be able to give a comparable reduction as they did at the previous sentencing.
And now when in the guideline, in the new 1B1.10, when we say substantial assistance, we mean 5K 1.1, 3553E, and Rule 35B.
That's right, absolutely.
Okay.
Okay, so the next question, I'll ask you, Krista. This defendant is eligible for a reduction in sentence pursuant to the amendment 750 Part A, again the drug quantity table. His guideline range under the drug trafficking guideline at 2D 1.1 has been lowered as a result of this amendment. However, at the time of the original sentencing, the defendant was also convicted of a count of felon in possession of a firearm. And so these counts grouped together and assumed the offense level of the drug count, because at the time that was the higher of the two counts.
Sure.
So now, however, when you apply the new amendment and the guideline at 2D 1.1, the felon in possession guideline is now the higher of the two counts. So the question is the court to sentence within the new amended guideline range for the drug count or the old range for the felon in possession count?
Well, that's a really good question. And as you stated earlier in the broadcast, as with any reduction in sentence proceeding, pursuant to 1B1.10 and the statute 3582, the court is only allowed to substitute the amendment listed at 1B1.10. So they're only allowed to look to that change in the drug quantity table. Now, we know in this case that changes the offense level for 2D1.1, and we know, because of the pre-sentence report, that the felon in possession count would have resulted in a greater offense level. So all other previous guideline decisions basically are remaining unchanged, except now the felon in possession count is a higher count. That doesn't change the fact that these offenses would still group together. It certainly doesn't change the fact that he was convicted of felon in possession at the same time he was convicted of the crack offense. However, the court would be limited to this new guideline range that is established by the felon in possession count being greater.
Right.
The court would not, therefore, be able to go to the new amended 2D1.1 guideline range because the grouping rules would still apply, and that guideline range, which results from the application of felon in possession, would be the controlling factor. So the court would be limited to the minimum of that amended guideline range. So it's still a reduction.
Right. But yet it's capped by the calculations for that felon in possession count. Right.
Exactly.
Okay.
Exactly. Okay, we have another one. Now, at the time of the previous sentencing for this defendant who was convicted of trafficking in crack cocaine, the court did not find a specific amount of crack. Instead, consistent with the plea agreement, what the court did was find a range of quantity and held the defendant accountable for 20 to 35 grams of crack cocaine. Now, at the time of the original sentencing, that resulted in a base offense level of 26 because a base offense level of 26 under the old drug guideline was 20 grams to 35 grams of crack. Now, however, the defendant may be eligible for a reduction in sentence as a result of the new drug quantity table, Amendment 750. But when you apply the amendment effective November 1st of 2011, a range of 20 to 35 grams of crack cocaine spans 3 different base offense levels under the new drug guideline. Base offense level of 22 at the low end of the range, base offense level of 24 at the middle range of that drug quantity, and a base offense level of 26 for the higher end of that crack cocaine quantity range. So the question is, how should the court determine the appropriate base offense level? Is it a 22 based upon the minimum of the range of the quantity of the controlled substance? Or must the court find the exact quantity of crack that the defendant trafficked?
Well, and see, this is a tricky question, but it's a good question because these are the types of things that happen in the real world of sentencing. And, you know, since the court didn't find a specific amount at the previous sentencing, you know, given the way the guideline operates and that no additional guideline decisions are to be affected, I don't think that the court has the authority to go back in and now try to determine what the quantity of, you know, the specific quantity of crack would be. And so if the court is inclined to give this defendant a reduction, since that quantity range, 20 to 35 grams, spans 22 and 24 and 26 base offense levels, you know, I think it wouldn't be a stretch to say that if the court wanted to go down to that 22 base offense level, they could do that. And again, the court would be in the unique position to make that decision.
Right.
And it's situations like this where it gets tricky because Part A does amend the quantity, but if you don't know what the exact quantity is, it sort of makes it difficult to apply the amendment retroactively. Now, we have one more question that I want to ask that we
Sure.
actually got faxed to us yesterday on the Fair Sentencing Act amendment. And that is, we've been talking about the guideline changes that have been made retroactive as a result of the Fair Sentencing Act. But this question focuses on the statutory penalties. You referenced in your discussion about the Fair Sentencing Act that legislation changed the statutory penalties for crack offenses. And so the natural question I think that flows is, are those statutory penalties retroactive?
Well, and as I mentioned, the Fair Sentencing Act was enacted on August 3rd of 2010. So for those people who were sentenced prior to August 3rd, 2010, they were sentenced under the old law. And so there is no retroactive application of the new mandatory minimum penalties for those defendants. Now, there is some circuit case law regarding defendants who were charged before August 3rd of 2010, but who were sentenced after August 3rd of 2010. So you'll have to look at particular circuit case law to interpret how those courts are viewing these new mandatory minimum penalties. But generally, there is no retroactive application of the new statutory minimum penalties for those people who were convicted and sentenced before August the 3rd.
Okay, great. Thank you again to those of you who have called on the helpline and asked us questions over the last couple of weeks and faxed in your questions as well. We're going to move on now and talk about the other amendments that the Commission made to the sentencing guidelines that went into effect November 1st, 2010. The Commission has amended the supervised release guidelines at 5D1.1 and 5D1.2 in response to a couple of things. Both the findings of the Commission's July 2010 report titled Federal Offenders Sentenced to Supervised Release, and changes in federal immigration law and the federal population, the offender population as a whole, over the last couple of years. Many of you may know that the largest number of cases sentenced under the federal sentencing guidelines are those involving immigration offenses. As a result, there is a new subsection at 5D1.1c that provides that, unless required by statute, supervised release ordinarily should not be imposed if the defendant is a deportable alien who will likely be deported after imprisonment. It's important to remember that this subsection is not limited to aliens only convicted of immigration offenses. Any deportable alien is subject to this amendment, and we've gotten this question as well. If a defendant is a deportable alien and, let's say, convicted of a robbery offense or a drug offense, this particular amendment would apply to that defendant. I also want to point out here is that the language says that supervised release ordinarily should not be imposed. This is not restricting the courts from ever imposing supervised release in these cases. It's simply giving the guidance that ordinarily, if you have a defendant who is a deportable alien, that the court should not impose supervised release. Again, it's not a prohibition on imposing supervised release in these cases. Now, additionally, this amendment lowers the minimum term of supervised release required by the guidelines for certain defendants when a statute does not require a higher minimum term. So for a defendant convicted of a Class A or B felony, the required term under the guidelines is reduced from a minimum of 3 years to a minimum of 2 years. The maximum of 5 years of supervised release remains the same. For a defendant convicted of a Class C or D felony, the minimum term of supervised release required by the guidelines is reduced from 2 years to 1 year, with the maximum term available remaining at 3 years. Additionally, this amendment to the supervised release guidelines at Chapter 5, Part D also provides guidance to the court for deciding whether to even order a term of supervised release, and if so, the length of that term of supervised release. For example, the guideline provides new language in the application notes that advises the court to consider, for example, the defendant's criminal history in determining the term of supervised release for that particular defendant. And the language reads exactly, in general, the more serious the criminal history, the greater the need for supervised release. The court is also directed to consider substance abuse considerations, as well as the factors at 18 U.S.C. 3553A, when imposing a term of supervised release. Now, moving on to the changes in the area of firearms offenses. The Commission has made amendments to the primary firearms guideline, that is 2K2.1, as a result of the Commission's review of these offenses, specifically those involving straw purchasers and firearms crossing the border. The guideline at 2K2.1 now provides increased base offense levels for straw purchasers convicted under 18 U.S.C. sections 922A6 or 924A1A, who commit the offense with the knowledge, intent, or reason to believe that the offense would result in the transfer of a firearm or ammunition to a prohibited person. The base offense levels generally are going to increase from 12 to 14. In some instances, you'll see an increase to an offense level of 20 if the offense involved certain firearms, such as semi-automatic weapons that are capable of accepting a large capacity magazine. The amendment also adds a new departure provision at application note 15 for certain less culpable straw purchasers. Now, this departure is going to apply to those defendants that are convicted of those straw purchaser statutes that I just mentioned, who do not receive any of the specific offense characteristics at 2K2.1, who were motivated by a specific relationship or threat or fear, and those who received no monetary compensation for the offense. Also at 2K2.1, you'll see a new alternative prong to the existing specific offense characteristic at B6. That's the in connection with specific offense characteristic. And this new prong is going to apply in a case in which the defendant possessed any firearm or ammunition while leaving or attempting to leave the United States, or in a case in which the defendant possessed or transferred any firearm or ammunition with the knowledge, intent, or reason to believe that it would be transported outside the United States. Now, some of these cases are also prosecuted under statutes that deal with items being smuggled off of the United States munitions list. And so those statutes that are used regarding the United States munitions list, the corresponding guideline for those is 2M5.2. And so the Commission has made some changes at that guideline to address some of the issues that you see in these cases. As you can see from our next slide, the guideline at 2M5.2 has two base offense levels, 26 and 14. So the first change you'll see here is that the threshold requirement of non-fully automatic small arms to trigger that 14 base offense level has been lowered from 10 to 2. We've also added language to address cases involving ammunition for these small arms. So if you have a case involving rounds that did not exceed 500, and it's ammunition for these small arms, and you either have the ammunition alone or the ammunition in conjunction with the small arms, those cases will also be eligible for a base offense level of 14. So that wraps up the changes as it relates to firearms offenses. But Krista, why don't you tell us about some of the changes that we'll see for illegal reentry offenses?
Absolutely. And as you mentioned, Rachel, you know, immigration offenses comprise the greatest percentage of offenses that we see in the federal system. Right. So this amendment will potentially impact a large number of people, just as we made changes to 2K2.1, which is also a pretty significant portion, not as big as immigration or drugs, but we did talk about amendments to the drug guidelines. So a lot of these amendments we're talking about today are going to have a big impact in that they are going to affect a good percentage of folks being sentenced under the federal sentencing guidelines. So having said that, let's turn our attention now to the illegal reentry guideline, 2L1.2. The Commission has amended 2L1.2 to limit the extent of the enhancement at subsection B1 for certain offenders. Now, subsection B1A under this guideline provides an increase of 16 levels for defendants with prior felony convictions of crimes of violence, firearms offenses, child pornography offenses, national security or terrorism offenses, human trafficking or alien smuggling offenses, or a drug trafficking offense for which the sentence imposed exceeded 13 months. The change that you see on the screen in the yellow color there now will show you that the guideline provides that if this prior conviction did not receive criminal history points under Chapter 4, Part A, the increase is limited to 12 offense levels instead of 16 offense levels. Now, in addition, a 12-level increase is provided in a case in which a defendant has a prior felony drug trafficking offense for which the sentence imposed was 13 months or less. So similarly, as part of this amendment, the Commission has amended this provision to limit the increase to 8 levels if the prior drug trafficking offense for which the sentence imposed was 13 months or less and did not receive criminal history points under Chapter 4. So the Commission is distinguishing now between prior convictions that did receive criminal history points under Chapter 4 versus those that did not qualify as countable under criminal history. Now, in addition to these changes, a new departure provision has also been added to this guideline, 2L1.2, for cases in which the new 12 or 8-level increase does not adequately reflect the extent or the seriousness of the conduct underlying the prior conviction. So in such a case, an upward departure may be warranted. We're going to turn our attention now to amendments to the fraud guideline, 2B1.1. And this amendment is in response to some directives the Commission received in the Patient Protection and Affordable Care Act of 2010. And these amendments also address certain new offenses that were contained in that act and in the Dodd-Frank Wall Street and Consumer Protection Act. So this amendment is in response to both of those pieces of legislation. Now, these new amendments are addressing healthcare fraud, and as I mentioned, the changes are found primarily in 2B1.1, the primary fraud guideline. So first, there's a new specific offense characteristic at 2B1.1B8, and this characteristic provides that if the defendant was convicted of a federal healthcare offense involving a government healthcare program and the loss under the loss table at 2B1.1B1 to the government healthcare program was of a certain amount, an increase of 2 to 4 levels is applicable. So if the loss is more than $1 million, 2 levels would be added to the offense level. If the loss is more than $7 million, 3 levels would be added. And if the loss is more than $20 million, 4 levels would be added to the offense level. Now, in addition, for further guidance on application of this new specific offense characteristic, the Commission has also provided definitions of federal healthcare offense and government healthcare program. These will be found in the application notes at 2B1.1. There is also a new special rule that has been added to application note 3F for determining intended loss in a federal healthcare fraud. Now, this rule states that the aggregate dollar amount of fraudulent bills submitted to the government healthcare program shall constitute
Prima facie
evidence of the amount of the intended loss if not rebutted. So you will find those changes in our application notes at 2B1.1. And finally, in conjunction with these healthcare fraud amendments, there is also a change at the mitigating role guideline, 3B1.2. And at 3B1.2, it has been amended to indicate that a mitigating role, a decrease for mitigating role under this guideline is not precluded for a defendant who is accountable under relevant conduct, that is 1B1.3, for a loss amount under 2B1.1 that greatly exceeds the defendant's personal gain from a fraud offense and who had limited knowledge of the scope of the scheme.
Now, that change was made obviously in response to these healthcare types of offenses, but there are some additional changes at the mitigating role guideline that I would like to discuss before we go on and answer a couple of more questions that we've gotten on some of these new amendments. The Commission has deleted unnecessary, what it considers to be unnecessary language from the mitigating role guideline at 3B1.2 that may have previously discouraged the application of this adjustment. Two phrases have been struck from the guideline. First, the Commission has removed this language. As with any other factual issue, the court, in weighing the totality of the circumstances, is not required to find, based solely on the defendant's bare assertion, that such a role adjustment is warranted. Second, the Commission has deleted from the mitigating role guideline the following language. It is intended that the downward adjustment for minimal participant will be used infrequently. And you know, Krista and I, we've been around the sentencing guidelines for a while now, and we know that there's a lot of case law on whether the courts give mitigating role, whether they don't, in courier cases. And so the Commission is made these changes at 3B1.2 in an effort to encourage the courts to use the mitigating role adjustment a little more frequently. And it makes sense also in the context of the Fair Sentencing Act and the amendments that were promulgated there. A lot of the focus is on the minimal role of a defendant in those offenses.
Now, I think it's time for us to turn to some additional questions we've received regarding these other amendments. But before we do that, I just want to remind everyone what we're giving you today is an overview of the amendments to the sentencing guidelines that are effective November 1st, 2011. There are other amendments that you will see in our materials for the broadcast in the reader-friendly versions of the amendments. Some are technical, some are to incorporate new offenses into Appendix A. So for a full list of those particular amendments, please look to the materials that are in association with our broadcast today. Now, having said that, let's respond to this first fax that we received.
This is a question specifically about the new amendments for supervised release under Chapter 5, Part D. And this case involves a defendant who is a deportable alien convicted of a drug trafficking offense. And again, remember when I talked about these changes, I said these will apply to not only defendants who are convicted of immigration offenses, but any deportable alien convicted of any type of offense. So this particular defendant's convicted of a drug trafficking offense, which carries a mandatory minimum term of supervised release. However, this defendant is also eligible for the safety valve, which erases that mandatory minimum term of supervised release. So the question is, does the judge have to order a term of supervised release to follow because of the otherwise mandatory nature, other than the safety valve, that is, mandatory nature of the supervised release term?
Well, and it's a good question. We've gotten this from a couple of places.
Right.
Corpus Christi sent us a similar facts this morning related to this issue. And so in a drug case in which the defendant qualifies for the safety valve, of course, the court no longer has a mandatory term of supervised release to impose. So therefore, a defendant who is a deportable alien, who is convicted of a drug offense, who is also eligible for the safety valve, may qualify under the new section at 5D 1.1c relating to deportable aliens and whether a term of supervised release should be imposed. And remember that at 5D 1.1c, that states that the court ordinarily should not impose a term of supervised release in a case in which supervised release is not required by statute and the defendant is a deportable alien who likely will be deported after imprisonment. So I think where there is a safety valve applicable to defendants in this particular circumstance, where they are deportable aliens, I think that 5D 1.1c will come into play.
Yeah, I agree. Did we have any other questions I think that we needed to address right now?
Not that I know of.
Okay. Again, if you have any questions on these new amendments, you can always call us on our helpline. If you have a real quick one that you want to fax in that we haven't received yet, you can try that as well. So what we've talked about today is obviously the new amendments that went into effect November 1st of 2011, including a discussion about the Fair Sentencing Act, which was originally promulgated last year as an emergency amendment. So it's promulgated November 1st of this year as a permanent amendment. So we discussed those changes as well as the retroactive application of that amendment. We talked about amendments regarding immigration offenses, regarding firearms offenses, supervised release, cases where there's healthcare fraud, that's right, mitigating role.
Right.
We've covered all those new amendments today. And again, as Krista said, this is an overview of sort of just a glossing over of all these new amendments, and additional information is available on our website. We've had the opportunity to answer some of the questions. Again, thank you for sending those to us ahead of time. If there's any other issues that present themselves as you work along and through with these amendments over the next several months, you can always call us on our helpline at 202-502-4545. Our website is www.ussc.gov, and there's always a lot of helpful information on our website as well. And that's all we have time for today. Thank you for joining us, and have a great day.